The annual report of guardian on condition of legally incapacitated individual. Hi, I'm Darren Findling of the Probate Pro, and we're going to go over this extensive document, PC 634. This is a state court administrative office. We call it SCAO, Form PC, Probate Court, Form 634. It is a document that I call extensive because it's multiple pages, and it is a requirement of all guardians to perform on a yearly basis, at least yearly, to show how the condition of the person upon which they are serving as guardian, how they're doing. Let's work our way through this particular document, and let's start with the statutory and court rule basis for the document. You'll notice that this document has been revised in July of 2024 on the revision date in the purple rectangle. It's very important that you use this most up-to-date form because most courts will not accept an earlier version. The reason that this document was primarily updated was because there was a statutory change in the addition of a standby guardian. So it allows for the inclusion of language in relation to the standby guardian. You'll notice that the form number is referenced in the bottom left corner, as well as the statutes and court rules that are applicable. You'll also notice that it is a 4-page document. Let's work our way through it. The top left corner is the case number. This is the file number. Top left corner is the county. Top right corner is the case number and the judge. You'll also notice at the top of the document, it allows you to identify if it's a final report. So for example, if the person is no longer in need of a guardian because it's been terminated or they have died, you would use that click box. Otherwise, it is typically done on the anniversary date of the appointment of the guardian. Now, it's really important that you calendar that date because failure to file the annual report on a yearly basis will subject you to becoming suspended or removed as the guardian. The court takes this responsibility very seriously to comply with the statutory requirement of at least yearly letting the court and the interested parties become aware of how the individual is doing. So please make sure that you calendar the date. Don't just simply rely on the court notifying you because they may not send it or they may send it to an incorrect address, and you could risk your suspension or removal as guardian. It'll identify that it should be completed yearly by the guardian or more often if directed by the court, and they must serve it pursuant to the court rule MCR 5.105 and MCR 5.125. It's very important that you read this court rule closely because the court rule identifies exactly who is needed to be served with this annual report on a yearly basis. It's not always so intuitive or simple to figure that out. So please refer to the court rule. In addition, after the annual report is completed and filed with the court, you have to complete a proof of service, return it to the court to show that you have appropriately notified the interested parties of the filing and service of this annual report. And again, remember, this is an annual report, not to be confused with an annual account. An annual account is used in a conservatorship. It's an accounting of assets. An annual report is used in a guardianship context, used to report on the condition of that person. Section 1, where it says in the matter of, this is the person upon which you're serving as the guardian for. Not who you are, but rather the person who is under guardianship. The next section under section 1 says I, and that's your name. You're the guardian, you're completing this form, and you're identifying the year. Now, the year will be exactly 1 year. So if, for example, you start on April 1 of each year, March 30th would be the end date. It is a calendar year typically unless the court directs otherwise. And then paragraph 2, pretty simple, the age of the individual upon who's under guardianship. The living arrangements, it identifies the current address and telephone number of that individual. B, where are they? Are they at a facility, in a hospital, or somewhere other than a typical residence? And then, of course, in paragraph C, you can use the checkboxes to identify the appropriate status of where their residence is, what type of residency it is. And then, of course, paragraph D has a time frame upon which they were being at that last residence. Now, it also gives you a space to identify if there was a reason for the change of residency during that year in paragraph 3D. on paragraph 3E, you get to identify how you characterize the living arrangements. Excellent, average, below average. So 3 options, pretty intuitive here how to figure that out. But then the explanation allows you to further explain the living arrangement of that individual. Paragraph F says that you believe that the individual is content or unhappy. And the individual they're referring to is the person under guardianship, not you as the guardian. How would they perceive the living arrangement? They like it or they don't. They're content or they're unhappy. Paragraph G is if you're recommending a more suitable living arrangement for the individual. Let's work our way on to page 2 of the document. You'll see in the top right corner there's a place to continue to put the case number. Physical health is identified here. And you can identify if their physical condition is excellent, good, fair, or poor, 4 options. And then during the past year, has their condition remained the same, improved, worsened, with an explanation. Now, in all those explanation spots where there's a short line, you have the option to attach additional information to that space. And paragraph C, of course, gives you an opportunity to identify the various forms of treatment that have occurred. It's often very difficult to put that information in that little space. You can summarize it or categorize it. For example, if it's monthly, courts usually let you do that versus every single visit. Because for some people, there are so many visits, it would be really difficult to fill it all in. But giving the court enough information and the interested parties enough information to know about the treatment that has gone on during the past year. Paragraph 5 applies to the do not resuscitate order provision. This is a very particular piece of the statute, MCL 700.5314D. There are rules and protocol about how you can obtain the authority to do a DNR in those particular set of circumstances. I encourage you to follow the statutory requirement very closely. In addition, for the physician's order and scope, or for scope of treatment, we call it a POST, post form, and then again, provisions relating to how to complete that. 7 talks about non-opioid directives. If those are in place, again, pretty self-explanatory. Paragraph 8, again, differentiating between the physical health. Now we're talking about the mental health. Exactly the same type of questions that are posed in paragraph 4 above. Excellent, good, fair, poor. During the past year, how have the conditions improved, worsened, or remained the same? And then particularity as to the treatment. Let's work our way onto page 3. Again, a space for the case number and a part that allows you to talk about the social activity and services. Again, similar as before. Excellent, good, fair, poor. Has it remained the same, improve, some opportunity to describe the activities that the individual has participated in the following year, as well as whether they're participating at all. And then paragraph 10 allows you to identify a more extensive list, again, dates and descriptions of social visits and contacts that have occurred. There's a statutory requirement for the guardian or representative to visit on a minimum of once every 90 days. More often we see a more regular visit, but statutorily it's a minimum of once every 90 days. Again, paragraph 11 talks about activities that the individual has participated in, and then consultation about particular decisions that may have been made. Maybe you consulted with them about their health, treatment, do not resuscitate requests, things like that would be included in paragraph 11, paragraph 12, and then if there's any unmet needs, it's referenced in paragraph 13. So what would an unmet need possibly be? Well, maybe they are not receiving sufficient mental health treatment or enough visits, whatever it may be, you'd identify it in paragraph 13. Paragraph 14 is really important because you're identifying whether the guardianship should be continued or should not be continued. Now, you may say it doesn't need to be continued anymore because the person may not need a guardianship anymore. Or you could say it should be continued if you believe that it should continue for another 12 months. In addition, if you are in a position as the guardian and you no longer want to serve, or maybe you can't serve because of health issues or other related issues, it's not that you're going to check the box that they should not be continued. The guardianship may need to continue, but you may be saying, well, I can't perform the role anymore for particular reasons. Maybe I'm moving, maybe my health is unable to continue to do this, or maybe I don't want to do it anymore. In that case, you'd use the petition to modify the guardianship in that particular set of circumstance. As well as if you believe that the guardianship is no longer needed, you should also file a petition to terminate the guardianship so that you can bring an end to the guardianship proceedings. Let's move to page 4 of the document. It identifies whether there's any money or cash upon which you are managing that hasn't yet been reported to the court, because there may be a need for a accounting within that guardianship or the establishment of a conservatorship because you are now managing assets of that individual. In Michigan, we differentiate between the care and well-being, a guardianship, and the assets, money, that is a conservatorship. Although within a guardianship, you have authority to manage certain amounts of monies under certain circumstances. Paragraph 16, if you are required to also do an annual account within that guardianship, that's the click box that you do. Then you've got the spot on the left side to put your date, the signature of you as the guardian, and if you've got a new address, click that checkbox. On the right side, if there's a co-guardian, it would also be signed there. You'd sign as co-guardian for purposes of that. And then the bottom section is really this piece about standby guardian. There's now, if the standby guardian has been designated, then if the standby guardian is unable or unwilling to serve, the standby guardian must promptly notify the court. And it's a signature spot for the designated standby guardian to indicate that they are continuing to willing to serve in that role as standby guardian during the upcoming number of years in the event of unavailability, death, or incapacity, or resignation of the existing guardian. So again, a pretty extensive document, lots going on here. I strongly urge you to consult with your medical team, your care team in preparation of this document. And then, of course, if you have a lawyer, to ensure that you're working with that lawyer to make sure that it's filled out correctly. At the Probate Pro, we are passionate about everything probate. If you've got a question about the annual report on condition of legally incapacitated individual or any probate or trust-related issue, visit us at theprobatepro.com or call us at 833-PROBATE.